Okay, we're going to read Florida versus Jardines. This was heard in 2013. And Justice Scalia delivered the opinion of the court. After police received an unverified tip that Jardines was growing marijuana in his home, they took a drug detection dog onto Jardines' front porch, where the dog alerted at the front door. On this basis, police obtained and executed a search warrant at Jardines' residence and seized marijuana plants, but the evidence was excluded below as the fruit of an unreasonable search. By reason of our decision in Katz v. United States, property rights are not the sole measure of Fourth Amendment violations, but though Katz may add to the baseline, does not subtract anything from the amendment's protections when the government does engage in a physical intrusion of a constitutionally protected area. That principle renders this case a straightforward one. The officers were gathering information in an area belonging to Jardines and immediately surrounding his house and the curtilage of his house, which we have held enjoys protection as part of the home itself. And they gathered the information by physically entering and occupying the area to engage in conduct not explicitly or implicitly permitted by the homeowner. The Fourth Amendment indicates with some precision the places and things encompassed by its protections, persons, houses, papers, and effects. The Fourth Amendment does not, therefore, prevent all investigations conducted on private property. For example, an officer may, subject to Katz, gather information in what we have called open fields, even if those fields are privately owned, because such fields are not enumerated in the amendment's text. But when it comes to the Fourth Amendment, the home is the first among equals. At the amendment's very core stands the right of a man to retreat into his home and there be free from unreasonable government intrusion. Silverman v. United States, 1961. This right would be of little practical value in the state agents if the state's agents could stand in a home's porch or side garden and trawl for evidence with impunity. The right to retreat would be significantly diminished if the police could enter a man's property to observe his repose from just outside the front window. We therefore regard the area immediately surrounding the associated with the home, what our cases call the curtilage, as part of the home itself for Fourth Amendment purposes. That principle has ancient and durable roots, just as the distinction between the home and open fields as old as common law. So too is the identity of home and what Blackstone called the curtilage or homestall. For the house protects and privileges all its branches and appurtenances. This area around the home is intimately linked to the home both physically and psychologically, and is where privacy expectations are most heightened. I'll write down the Silverman case about repose and retreat. Retreat. While the boundaries of the curtilage are generally clearly marked, the conception defining the curtilage is at any rate familiar enough that it is easily understood from our daily experience. Here, there is no doubt that the officers entered it. The front porch is a classic exemplar of an area adjacent to the home and to which the activity of home life extends. Since the officers took place in a investigation took place in a constitutionally protected area, we turn to the question of whether it was accomplished through an unlicensed physical intrusion. While the law enforcement officials need not shield their eyes when passing the home on the public thoroughfares, the officers leave to gather information. And officers leave to gather information is sharply circumscribed when he steps off those thoroughfares and enters the Fourth Amendment protected areas. As it is undisputed that the detectives have all 4 of their feet and all 4 of their companions firmly planted on the constitutionally produced extension of Jardines' home, and only question is whether he had given his leave, even implicitly, for them to do so. He had not. A license may be implied from the habits of the country, notwithstanding the strict rule of the English common law as to entry upon the house. This implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Complying with the terms of that traditional invitation does not require a fine-grained legal knowledge. It is generally managed without incident by the nation's Girl Scouts and trick-or-treaters. Thus, a police officer not armed with a warrant may approach a home and knock precisely because that is no more than any private citizen might do. But introducing a trained police dog to explore the area around the home in hopes of discovering incriminating evidence is something else. There is no customary invitation to do that. The invitation to engage in canine forensic investigations assuredly does not inhere in the very act of hanging a knocker. To find a visitor knocking on the door is routine, even if sometimes unwelcome. To spot that visitor seem exploration in front path with the retail marching has bloodhound into the garden before saying hello and asking permission would inquire most of us all well call the police. When would inspire most of us well call the police. In the scope of the license expressed or limited license not only to a particular area but also to a specific purpose. Here, the background social norms that invite a visitor to the front door do not invite him in to conduct a search. The state profits to the decisions holding under the subjective test or intent, of the officer is irrelevant. But those cases clearly hold that a stop or search that is that is objectively reasonable is not vitiated by the fact that the officer's real reason for marking the stop or research has nothing to do with the validating reason. Here, however, the question before the court is precisely whether the officer's conduct was reasonable on search, as we have described, and it depends on whether the officers had an implicit license, implied license to search the porch, which in turn depends upon the purpose for which the customers must purpose to conduct, which is not what anyone would think he had license to do. The state argues that investigation by a forensic narcotics dog by definition cannot implicate any legitimate privacy interest. The state cites the for authority are 1986 and Illinois versus Cabalas. But we need not decide whether the officer's investigation of Jardines' home violated his investigation. I had reached the end of the case, basically. Last paragraph, just to remind, is, but we need not decide whether the officer's investigation of Jardines' home amendments property right baseline is that it keeps easy causes entry. The property to gather evidence and is enough to establish that a search conducted. All right. I'm pretty sure I can go no further. But there is dissenting and concurring opinions. So I might be able to tell you at least who agreed, disagreed. So Kagan, Ginsburg, Sotomayor joined concurring. Alito, Chief Justice, Justice Kennedy, and Justice Breyer dissent. It's 3 pages. See what they have to say. The court today treats this case under property under property rubric. I write separately to note that I could just as happily have decided it by looking at Jardines' privacy interests. A discussion along those lines would have looked well much like this one. It is not surprising that in a case involving the search of a home, property concepts and privacy concepts should so align. The law of privacy naturally involves influence, our shared social expectations of what places should be free from governmental incursions, and so the sentiment, my home is my own, while originating in property law, now also denotes a common understanding, extending even beyond that law's formal protections about an especially private sphere. Jardines' home was his property. It was also his most intimate and familiar space. The analysis proceeding from each of those facts that today's decision reveals runs mostly along the same path. I can think of only one divergence. If we had decided this case on privacy grounds, we would have realized that Kylo versus United States 2001 had already resolved it. The Kylo court held that police officers conducted a search when they used thermal imaging device to detect heat emanating from a private home, even though they committed no trespass, highlighting our intention to draw both a firm and a bright line at the entrance to the house. We announced the following rule. Whereas here, the government uses a device that is not in public or general public use to explore details of the home that would previously have been unknowable without historical intrusion, the surveillance is a search and is presumptively unreasonable without a warrant. That firm and bright rule governs this case. So this is the rule. Whereas here the government uses the device that is not in general public use to explore details of the home that would previously have been marked unreasonable. A firm and bright rule governs this case. The police officers here conducted a search because they use a device not a general public use, a trained drug detention dog to explore details of the home, the presence of certain substances, and that they would not otherwise have discovered without entering the premises. And again, the dissent's argument that they would have to do something there. Anyway, the police officers here conducted a search because they used a device, not a general public use, a trained drug detention dog to explore details of the home, the presence of certain substances that they would not otherwise have discovered without entering the premises. And again, the dissent's argument that the device is just a dog cannot change the equation. The Kylo made clear the sense-enhancing tool at issue may be crude or sophisticated, may be old or new, may be either smaller or bigger than a bread box. Still, as here, the device is not in general public use, training it on a home violates our minimal expectation of privacy, an expectation that exists and that is acknowledged to be reasonable. With these further thoughts suggesting that it focuses on Jardines' privacy interests would make an easy case easy. A choice over I join the court's opinion in full. Justice Alito, with whom Chief Justice Kennedy and Breyer dissenting. The court concludes that the conduct in this case was a search because Detective Bart helped exceed the boundaries of the license to approach the house that is recognized by the law of trespass, but the court's interpretation of the scope of that license is unfounded. It is said that members of the public may lawfully proceed along a walkway leading to the front door of a house because custom grants them license to do so. This rule encompasses categories of visitors whom most homeowners will certainly wish to allow to approach their front doors, front relatives, mail carriers, persons making deliveries, but it also reaches categories of visitors who are less universally welcome, solicitors, hawkers, peddlers, and the like. Of course, this license has certain spatial and temporal limits. The visitor must stick to the program sticks to the path that is typically used to support a front door, such as a paved walkway, nor as a general matter may a visitor come to the front door in the middle of the night without an express invitation. Similarly, a visitor may linger at the front door for an extended period, and the license is limited to the amount of time it would customarily take to approach the order. Pause long enough to see if someone is home. If not expressly invited to stay longer, leave. As I understand the law of trespasses and the scope of the implied license, a visitor adheres to these limitations is not necessarily required to ring the doorbell, knock the door, or attempt to speak with the occupant. For example, mail carriers, persons making deliverables, and individuals distributing flyers may leave the items they are carrying and apart without making the attempt to converse. As the majority acknowledges, the implied license to approach the court of law, the front door, extends to the police. Even when the objective of knock and talk is to obtain admissions, still applies. In other words, gathering those expectations In other words, gathering evidence, even damning evidence, is an unlawful activity characterized by illegal. All right, Detective Bartlett, blah, blah. Okay. The license to approach still applies. In other words, gathering evidence, even damning evidence, is a lawful activity that falls within the scope of the license to approach. Detective Bartlett did not exceed the scope of the license to approach respondent's front door. He adhered to the customary path. He did not approach the middle of the night, and he remained at the front door until a waiver, short period less than 1 minute, to review or to the court must fail or fell. What the court must fall back on, then, is the particular instrument that Detective Bartlett used to detect the odor of marijuana, namely his dog. But if the entire body of common law decisions, the court has not made a single case holding that a visitor to the front door of a home commits a trespass if the visitor is accompanied by a dog on a leash. On the contrary, the common law allowed evidence and provided evidence. I'll leave it at that. On the contrary, the common law allowed even unleashed dogs to wander on the private property without committing a trespass. Concurring opinion attempts to provide an alternative ground for today's decision, namely that Bartlett's conduct violated respondents' reasonable expectation of privacy in an attempt to show that respondent had a reasonable expectation of privacy in the odor of the marijuana wafting from his house. The concurrence argues that in this case, just like Kylo versus United States, which held that police officers conducting a search when they used thermal imaging device to detect heat emanating from the house, this court, however, has already rejected the approach that the use of drug sniffing dog is the same as the use of a thermal imaging driver. Contrary, so this is the next paragraph. Contrary to the paragraph propounded by this concurrence, Kylo is best understood as a decision about the first of new technology. A dog, therefore, is not a new form of technology or service based on new business initiatives. Much like the actual decision of the court, but that is simply not so. The concurrence's Kylo-based approach will not have a wider reach when the police officer Okay, now I'm done.